Dear participants, a very warm welcome to this lunch webinar. I'm Professor Pascal Pichonnat from the University of Fribourg, Switzerland, and as president of the European Law Institute, it is my great pleasure and privilege to welcome you all to this webinar. In February 2024, ELI membership has approved the so-called ELI Charter of Fundamental Constitutional Principles of European Democracy. This very important output has been finalized in a time in which issues of fundamental constitutional principles are more important than ever. For those of you who attended already the previous webinars on the topic, you know that the ELI decided to organize a series of webinars to discuss the different parts of the ELI Charter of Fundamental Constitutional Principles. This webinar is already the sixth one. There will be one more to discuss part 7 of the charter, and information will be posted soon on the chat. The recordings of all 5 previous webinars are already available on the ELI website so that you can go back to them at any time or even use them as a source of information for some lectures or even teaching material that you may have. Today's topic, protection of fundamental rights, is part 6, which covers topics as large as the application to private parties of the obligation to respect fundamental rights, environmental protection and sustainability, right to international protection, social solidarity, and automated decision-making. We will not be able to cover all of them in the same detailed analysis, but Professor Elise Muir will give a brief overview on all of them in a minute or so. The 2 reporters of this project are Professor Elise Muir and Professor Takis Tridimas. They have achieved a wonderful work under the chairmanship of Sir Francis Jacobs, former president of the ELI, and Sir Geoffrey Jowell. As for all projects run by the ELI, this project has also benefited from inputs of internal bodies of the ELI, our scientific director, Professor Christiane Evenderos, our executive committee, and the ELI Council, as well as the assessors, advisors, and members of the membership consultative committee. Moreover, the project has been presented at several occasions, including at high-level constitutional law conferences. In a way, this webinar is a further opportunity to reflect and discuss the impact and the role of a proper and encompassing protection of fundamental rights. And I truly look forward to the presentations of our fantastic panelists of today. But before starting, let me remind you that you will be able to ask questions through the Q&A function, and we will answer those questions orally during the Q&A session just after the first round of presentations. Now, let's start with our first panelist, Professor Elise Muir. She's professor of EU law at KU Leuven. She has a particular interest in EU constitutional and fundamental rights law, as illustrated by her 2 monographs in the field, published in 2012 by Kluwer and 2018 at OUP. She's a principal investigator of the Reshuffle project, a European Research Council project, which deals with the transformation of the institutional landscape for the protection of fundamental rights in Europe. She has recently published a handbook on an introduction to the EU legal order by CUP 2023. And of course, she's one of the 2 co-reporters. And so she will briefly introduce now the Charter and part 6 on protection of fundamental rights. Professor Muir, you have the floor.
Thank you very much, President Pichonnat. It's a great pleasure to be back on one of these ELI web seminars to present the Charter of Fundamental Constitutional Principles for European democracy. As you have very kindly introduced already, this project is a collaboration, and so I am here speaking on behalf, in fact, of a group of contributors, as I will further explain in a minute. Perhaps I can briefly start with why these projects. I guess it is no mystery that there are a number of profound challenges to the fundamental principles on which our European liberal democracies are funded within Europe, outside of Europe, in many, many forms, be it through conflicts, politics, the governance of the digital sphere. So a broad range of challenges, which I think explain why the LI has felt it was the right time to reflect on how to assert, reassert, and perhaps be a bit forward-looking as well, on what are the fundamentals of European liberal democracies. So we have accepted with great pleasure, together with Takis Tridimas, to act as reporters for this project under the chairmanship of Sir Francis Jacobs and Sir Geoffrey Joel. It's been an honor, and so therefore I'm only here one of the reporters and one members of the group. I should also stress that this has been a much more collaborative work than what these four names suggest, because there has been a team working on the project, there's been an advisory committee, and importantly, there's been a broad range of consultations, as you have pointed out already, President Pichonnet. The project has been presented and discussed in a variety of fora. But we know, Professor Tridimas and myself, the chairman as well, that the work remains imperfect and open to improvements and will have to be updated. So this is why we are very happy to continue these discussions as this opportunity today makes it possible. So I've explained a bit the why and the who. Now, how? What has been our method? We, first of all, have made a choice to focus on European democratic principles or European principles for European democracy. So there is a sort of a geographical focus. The idea, therefore, is to go beyond the EU, to look at the continent. But I have to say, we also took into account various sources from outside of Europe. And the intention is also to have global resonance. So while our primary focus is Europe, we have tried to remain open to interactions with other liberal democracies outside of Europe and what we could learn from them. We have had a deliberative process. So the project is primarily an academic exercise, and that you can tell from just looking at the project members, the chairs. But of course, we've been in contact with practitioners, with civil society actors, with members of institutions, thanks to the LI network. And the sources that we really have used to capture the principles have been primarily official documents from the Council of Europe, the EU, constitutional legal systems across Europe and across the world, but also academic works, right? So there is a diversity of sources there. And in fact, in reporting on these sources, which the Charter does, we are not being exhaustive. So we're just trying to capture a balance at a given time. And that brings me to the next point, which is, what exactly have we been trying to do? So why, who, how, but what exactly have we been trying to do? We've been trying to find the right balance between being descriptive, that is putting together a number of acquired sets of principles, rights, and balances of a constitutional nature, on the one hand, and on the other hand, trying to be a bit forward-looking, being aware of the fact that we need to go a bit beyond what already exists, simply because the challenges are there and because the world we live in is evolving, and we need to be able to capture and to contribute to how we could address new challenges. So for example, on automated decision-making, this is something we'll come back to, or the protection of the environment. We're trying to go a bit beyond what is already established in standard constitutions. The structure of the Charter will now be shown on the screen. I have tried to, with the help of a colleague from ELI, whom I thank, to put this in a few slides. So the Charter is structured in 7 parts, which in fact bring together a set of 36 principles. Each of the part has been the subject matter of a webinar, as Professor Pichon has stressed. So one on liberal democracy, one on the rule of law, one on judicial independence, one on checks and balances, accountability, one on dignity and equality, and one on the protection of fundamental rights being discussed today, and then one on constitutional integrity. We, the reporters, the chairmen, the chairs and the group recognize that there is an overlap between these different parts. But we felt that by categorizing the principles, we would send a signal that these are the key points we wanted to articulate the charter around. Now, for each principle, so 7 parts, 36 principles, for each principle, there is a commentary of a page to 3 pages that explains how we came to the wording of the principle. So in fact, it captures the sources of inspiration we have used and tried to shed light on what we had in mind when we formulated the principle. Again, this is not an exhaustive exercise, and this is something that may have to be updated in the future. Now, for today, we've been asked to focus on part 6, the protection of fundamental rights, which is itself composed, as you can now see on the screen, of 6 principles. And what I propose to do is to briefly go through each of them so as to give you a short introduction, and then I'm sure in the discussion with the panel members and with the audience, we may want to come back in more details on some of them. Perhaps before I move on, though, I shall say that just before part 6, and I'll come back to the previous slide, just before part 6 is part 5, which was devoted to dignity and equality. So we singled out the idea of human dignity, non-discrimination, equality, as a set of principles that we wanted to assert even before going further on fundamental rights. These were presented in a previous webinar, but the idea was that human dignity is central to the functioning of European liberal democracies and closely related to the idea of equal treatment and non-discrimination. Now, with this brief introduction, allow me to move into and delve into the principles encapsulated in part 6. The first principle, which you now see on the screen, I'm not going to read out each principle. I'm just going to point out the key features of each principle. And again, there is a commentary next to them if you're interested, and you will find this on the website of the LI. So Principle 27 is a fairly general one. It is devoted to the protection of fundamental rights. What we did not want to do in this charter was to repeat and reproduce every single right that is already to be found in the European Convention on Human Rights or the European Social Charter. We, however, cross-refer to them, if you would like, in this Principle 27, where we state that a liberal democracy must guarantee effectively protect the rights and freedoms enshrined in the ECHR, the European Convention on Human Rights. And we also wanted to pay tribute to the European Social Charter. This is the second paragraph, by recalling that states have a duty to uphold not only civil liberties, but also social and economic rights, which are to be found in particular in the European Social Charter. Our idea here is that the European Convention, is a very rich instrument already, interpreted by the European Court for Human Rights actively on a regular basis. We therefore incorporate all this acquis in the Charter. We also wanted to reiterate that the European Social Charter is in fact in different ways, very influential in the constitutional systems of European liberal democracies. I will come back a little bit to social and economic rights in a minute, because we have a principle which is specifically devoted to social solidarity, Principle 31. Finally, Principle 27, which looks at fundamental rights in general, also acknowledges that many fundamental rights are not absolute. They are subject to limitations, but these limitations must follow certain patterns to be accepted. They must be provided by law, they must be proportionate, and they must respect the essence of the rights at issue. This is inspired from a provision of the Charter of Fundamental Rights of the EU, but the ECHR has a similar approach to the structure of limitations to convention rights. So sort of an introduction to fundamental rights, restating the acquis. We then decided to select a number of fundamental rights other than human dignity, equality, and non-discrimination, which were already touched upon in the Charter. So a set of other fundamental rights, which we believe are particularly relevant in the contemporary society we live in. The first one is a horizontal principle, the idea that the respect for fundamental rights is relevant not only for public authorities, but also for private parties. So this is a sort of a horizontal or structural principle. There is much diversity in how European states address the issue of the horizontal effects of fundamental rights. But there is little doubt that in many ways, fundamental rights can have implications for private parties. Why does that matter? That matters because today, private actors contribute in significant ways to the organization of public life and may intrude in significant ways in individual rights. So the idea is to assert that in the private sphere as well, there must be a respect for fundamental rights. In particular, as paragraph 2 states, in case of non-state parties which have by their nature or their economic activities, a particularly strong impact on respect for human rights or on the rights of individuals, but not only. Principle 29 looks more specifically at the protection of the environment and sustainability. Here, as you can see, the principle is structured in four paragraphs. The idea is to reassert that states must provide a high level of protection of the environment and sustainability. That, as you can see from the subparagraph 2 of paragraph 1, there must be effective judicial remedy. So there must be ways of enforcing compliance with the right to protection of the environment. Paragraphs 2 and 3 are a bit more related to the governance of environmental protection, so requiring the integration of environmental concerns throughout policy shaping and adoption, and calling for coordinated action at international level, which is necessary to address challenges related to the environment and sustainability. And finally, it is acknowledged in paragraph 4 that not only states, but also private parties have an important role to play in the protection of the environment and sustainability. Principle 30 is devoted to the right to international protection. We reassert the right to asylum, which is to be found in the Geneva Convention, a convention from the United Nations, and which is also mentioned in many constitutional systems across Europe and the globe. We also reassert the need for legal protection of refugees in accordance with the principle of non-refoulement. The very idea of non-refoulement has been subject of much case law from the European Court for Human Rights. And that is also a bit related to the third point, the idea that a state must protect anyone who would face a real risk of suffering serious harm. The mindset behind this third paragraph is important because we wanted to show that there is not only strong international commitments and European constitutional commitments to protect people who are at risk of persecution due to certain criteria, such as race, nationality, religion. These are the requirements to receive the status of refugee, but also people who are at risk of suffering a real risk people who face the real risk of suffering serious harm, even if they do not qualify for refugee status. The reason for our attachment to this is that this has been, again, the subject matter of much attention in Europe, in particular in the context of European Union law, where people are protected against this form of subsidiary or receive this form of subsidiary protection in case they do not qualify for refugee status. And of course, we take note of the fact that states have the power to control their borders, but they must do so in compliance with international law obligations. The principle of social solidarity, which I briefly touched upon earlier on, is intended to assert the need for the state to develop proactively a certain degree of welfare support, in particular in the field of health, education, housing, and basic means of subsistence. The idea is that there cannot be a functioning liberal democracy or functioning liberal democracies if people and citizens do not benefit from a minimum of well-being. Education here is particularly important for the good functioning of democracies, as highlighted in the comments. We also point out that not only states, but also non-state entities and civil society may contribute to the distributive nature of social solidarity. And last but not least, a word on automated decision-making. Automated decision-making is a principle we have decided to include in this part on fundamental rights. It's a bit forward-looking because we acknowledge in the comments that there is no common established set of norms of a constitutional nature addressing and framing your automated decision-making in Europe at the moment. But we also felt that we could not ignore the related challenges. So the overall position we took to address this is to, in fact, take the view that automated decision-making cannot lead to a lowering of the standards of protection of individuals. That's what we read in our paragraph 1. So the use of automated means to take decisions which affect the individual shall not undermine safeguards and levels of protection already applicable to protect individuals. And in order to achieve this, we assert the need for transparency and accountability whenever automated decision-making is being used, paragraph 2. And in certain circumstances, when automated decision-making may have substantial effects on the rights of individuals, then we call for laying down the related categories of decision-making into law and ensuring a degree of human review. And we reassert the need for possible judicial protection, which cannot possibly be diminished simply because decision-making is based or includes forms of automated decision-making. With this overview, President Pichounaz, I'm more than happy to open, I look forward to further discussion of the principles. Thank you very much for your attention.
Thank you very much, Elise Muir, for this overview, which helps really to have a kind of landscape of this chapter and also put some light on some specific articles. And now we will continue and go deeper on some of them, thanks to our other panelists. And first, I have the pleasure to introduce Geert van Kalscher. He's a full professor at the University of Leuven and visiting professor, among others, at King's College, London, and also at Monash, Melbourne University. Geert serves for the EU on the dispute settlement panels of a variety of international trade agreements, including the UK-EU TCA. He's also an independent legal practitioner at the Brussels Bar, and his practice, teaching, and research focus on conflict of laws, EU and international regulatory law, especially environment and energy, international EU economic law and commercial and investment arbitration. And he will focus today on Principle 29, environmental protection and sustainability, and delivers some of his reflections. We are looking forward to it. Geert van Kalster, you have the floor.
Thank you very much. Thank you very much for the opportunity to speak at the seminar, and particularly indeed on Principle 29. I have 10 minutes to do so, so I won't spend too much time on all sorts of introductions. I do want to say indeed, and thank you, Professor Pichonnat, for mentioning those various backgrounds, because I suppose that some of the things that I'll be saying might be informed by, first of all, the fact that I am not just an environmental lawyer, but indeed also a I suppose more sort of commercial litigation kind of lawyer. I have quite a lot of experience with some of the businesses to whom Principle 29 is addressed, and that might certainly explain some of my comments, I think, on how the principles are phrased, etc. But also, as you mentioned, Professor Pichonnat, I'm also a practitioner, and again, that might explain some of my perhaps more cynical views that I might be expressing on some of the realities of these principles. I don't have many slides, and all I've done on the slides is just simply put up the text again of Principle 29 and the one or two bits that I wanted to focus on, so as you can kind of follow, even if you don't have the principles in front of you. I think first of all, and we'll get back to that later when we talk about litigation and litigating the principles, I think first of all, it is a very, very applaudable effort to write these principles and to think about how they may be operationalized, because it's clear from the recent perhaps sort of five or 10 years or so that recourse by a whole bunch of stakeholders to principles to try and further the environmental and the sustainability agenda has taken a massive flight. That is most probably not just because it has in some ways become easier to litigate these principles, but it is also, of course, because the failure of direct regulation to address these environmental and sustainability concerns, I think, has become very clear as well. And that starts perhaps with my first comment on the first element of Principle 29.1, which is the high level of environmental protection. That, of course, is something which the EU lawyers amongst us will be very familiar with, at least as stated in principle. I think what I certainly like about the way in which the principle is phrased is that it is not unlike its counterpart in the TFEU, the Treaty on the Functioning of the European Union. It is not immediately linked to a whole series of limitations to that high level. If you look at how the European Union's environmental policy works, then the high level of environmental protection is posited as a starting point, but it is immediately nuanced by a number of elements which the European Commission must take into account, and which, of course, the European member states and Parliament also take into account. And these are elements such as the balanced development of the regions, both economically and socially, the state of the art in terms of environmental science. Some of those elements make an awful lot of sense. To give a very obvious example, the way air pollution works in deserted northern Finland is, of course, very different from how it works in very busy downtown Brussels or Amsterdam. So there's a clear scientific element as to why you shouldn't have the same level of environmental protection across the whole of the EU. But as you would imagine, the very many elements of nuance in the treaty on the functioning of the European Union in practice have led to an awful lot of downgrading of environmental protection, particularly in recent years. And it's also clear, I think, from the way in which the EU's Green Deal has been watered down tremendously as compared to the initial ambitions of the European Commission. Of course, the article doesn't just talk about environmental protection. It talks about promotion of sustainable development. Now, sustainable development, as the commentary to the principle also explains, of course, has those three pillars: environmental protection, economic development, and social development. And here too, over the years, we've seen that the presence of economic and social development in sustainable development has led to or has effectively granted a jack to an awful lot of opponents of strong environmental protection to halt or certainly slow down the environmental agenda. It is commonplace for industry in particular, but also for a number of member states, to always put a brake on environmental protection, arguing that at the end of the day, we also have a right to economic and indeed social development. And if you look at that in an international context, including, of course, the wider European context, which these principles aim to address, then, of course, you very quickly get into discussions on common but differentiated responsibility. You get into discussions on level of comfort and sort of style of living. And of course, that again has slowed down environmental protection probably much more than one might have hoped. Clearly, I'm not advocating that we shouldn't have any attention to economic or social development, but it is clear that the three-pillar structure of sustainable development has led, in effect, to the environmental pillar suffering quite importantly. The second element of this principle, which you see in the second paragraph and which Professor Muir has also already referred to, is this element of effective remedies. This is really, really crucial, that the principles should call, or should first of all indeed posit the idea of, if you like, the policymakers and of course industry, I'll get back to that later, promoting sustainable development, but then emphasizing this very important role which citizens and stakeholders generally should have in ensuring that they have these effective remedies to get environmental protection effectively complied with. Here, of course, you see an interesting contrast between the reference to environmental protection in the second paragraph as opposed to sustainable development, the wider message in the first paragraph. I'm not sure if that's intended, but it's something that caught my eye when you look at the effective remedies element. Of course, those of us who are familiar with the European Union will be very much aware that in the EU, it is particularly the European Union level itself, more perhaps than the member states, that often fails in providing these effective remedies. And I note with great interest and enthusiasm that Sir Francis was, of course, involved in drafting these principles. And as many of us know, he is someone who has tried, in his role as Advocate General at the CJEU, to move the goalposts in terms of access to remedies against EU institutions in environmental matters, and of course failed to some degree in light of the obstinance of the Court of Justice itself to move from its very restrictive stance on locus standi in the Court of Justice. Moving to the second principle, the integration principle. It's, I'm afraid, again, one of those elements which is very easy to achieve at a policy level, and the European institutions in particular, but also national institutions, often pay an awful lot of lip service to the issue of integration, paying attention to environmental elements in the remainder of a state policy. But in reality, of course, the integration principle very often has become a bit of a tick box exercise. And it is clear that even when it is specifically mentioned in a number of environmental instruments, that it is not really effectively implemented. To give you one very straightforward example, if you look at the guidelines for state aid in the European Union, then they say specifically that no state aid must be granted for environmental purposes to anyone who, under the applicable law, might actually be liable for the pollution that they have caused. And if you then compare the doling out of massive amount of subsidies by member states to industry players who clearly have caused an awful lot of pollution, often in the very project for which they now receive state aid, then it is obvious that this principle is simply ignored in reality. So that doesn't mean to say that it shouldn't be emphasized in policy or in documents like the one that we are discussing today, but one should be very much aware that the implementation of the integration principle lacks an awful lot of discipline and policing. And if one inquires with the European Commission about these issues, then one simply gets a bit of a shrug, I'm afraid, in terms of why they don't see this as a priority. Third principle, the coordination to achieving common standards for sustainability and environmental protection. I am very much a multilateralist, and I certainly applaud the message which is included in this principle that clearly there must be international cooperation within the scope of Principle 29, as of course there must also be for all the other principles in the draft instrument. But it is also clear that the coordination element may again be an excuse for recalcitrant states to slow down international efforts. And I, for one, am very much an advocate of unilateral action to try and move the goalposts on a number of these environmental and sustainability issues. Again, a specific example, the European Carbon Border Adjustment Mechanism, which finally introduces a sort of level playing field purpose in terms of carbon emissions between European imports and European home-produced products. Clearly, I think that is very much the way forward. If jurisdictions like the European Union were to wait for this coordinated action to finally achieve some results in climate change or other measures, then I'm afraid the ship will have sunk before we finally get somewhere. So it's probably a call to yes, we must still invest in coordination and international cooperation, but we must not shy away from unilateral action to try and further the sustainability agenda. And of course, there are ways in which this can be disciplined, as I'm sure the CBAM will show as well, because India in particular has signaled that it will be litigating CBAM at the WTO. Finally, the reference to industry and state in Principle 4. I am not sure I'm very convinced that it is good to introduce this in an instrument of this nature. I'm afraid reality shows that industry, particularly organized industry, not so much perhaps the small SMEs, but the larger industry, that they will use any opportunity to try and sink any sort of ambition in sustainability and or environmental protection. I'm very much here with Adam Smith, who, unlike what people commonly think of his ideas on regulation of the market, very much put the responsibility for regulation of negative externalities, such as in his time labor standards, but of course nowadays also environmental protection, very much puts that responsibility in the hands of government, not in the hands of private industry. And I don't think it is a good idea to expect too much of this sort of solidarity idea amongst industry. Industry is there to make money, not, I think, to really have much genuine eye for environmental protection. And I finish with this reference to strategic and public interest litigation. In the commentary as well, there is references to a number of cases. Some of them, in the meantime, unfortunately reversed, such as Sharma in Australia on a common law duty of care for climate protection. But it is clear indeed that there are a variety of reasons why public interest litigation has really taken off, I think for good reason. I won't discuss those reasons today, but it's clear that that we must continue to put efforts into and encourage this kind of action alongside regulatory responses to the many challenges in environmental law. I've spoken a little bit too long, so I will finish straight away there.
Thank you very much, Professor Van Kolster, for this analysis and pointing out also two very important points on which we will certainly come back in the discussion. We indeed continue without further ado with Judge Catherine Kotsopoulou. She's an administrative judge since 2010. She is sitting at the Special Migration and Asylum Chamber of the Administrative Court of First Instance of Athens. And between 2016 and 22, she was also a member of the Independent Appeals Committees hearing international protection cases. She has provided trainings in refugee law for the Greek National School of Judges, EUAA and EGTN on EU level. And since 2020, she's the vice president of the International Association of Migration and Refugee Judges. and the co-chair of the Asylum and Immigration Working Group on the European Association of Administrative Judges. She holds a PhD in refugee law and currently performing her postdoc research in refugee law, asylum policy. I wanted to say, Madam Judge, you are just Madam Refugee Law, and therefore we are very much interested on your reflection on Principle 30 on the right to international protection, linked, of course, to these issues. You have the floor. Thank you.
Thank you very much, Professor Pichonaz. Thank you very much for inviting me here today. And from a judicial perspective, I have to admit that the chapter, you have done an amazing work, and I'm pretty sure that it will be definitely a piece of reference for all of us. And it's also the right time to have this kind of proposal because over the last several years here in Europe, we have faced profound challenges in the rule of law. So I'm asked to comment on Principle 30. And please allow me with a general comment. The way I see it, migration seems to dominate the discussion in politics, in economies worldwide, in some surprising place and in some surprising ways. Take, for example, the States or UK's trouble, or Ireland or South Africa. So the way I see it, migration is, and asylum is basically a political issue that I understand that it divides voters in a way that very few other subjects divide. Why? Because over the last years, we have a populist movement pushing a narrative that migration has gone out of control. And as a result, we see a patchwork of policies, restrictive policies to asylum seekers. What is the answer to this populist movement? I think it's the proposal to have a constitutional right in our constitution, right to asylum in our constitutions. Why? Because the way I see it, in this era of growing nationalism, where the states become over and over more skeptical on international agreements or regional agreements, if we constitutionalize the right to asylum in our own constitutions, then it will be very difficult for criticism, for nationalist criticism. We cannot actually say that it was imposed because it is a decision made from our societies. It is the law of the land. So I think this is very important. Also, the fact that we have a constitutional right in our right to asylum, I think it upholds humanitarian values by providing protection to people in need. And at the same time, it reflects a nation's commitment to international obligations. It signals that the state is ready to fulfill these international obligations. And at the same time, I think it can provide legal clarity to the country's legal framework. Now, as regards, was my general comment. And as regards now the Principle 30 of the Charter, the proposed Principle 30, what I say is that we have a comprehensive legal construction. Why? Because Principle 30 actually emphasizes the importance of recognizing and upholding the right to international protection to people fleeing their homes because of persecution, because of armed conflicts and other forms of serious harm. And we see that in paragraph 1, the principle acknowledges the legal framework that is established by the international community. I refer to the Geneva Convention, but also includes elements from the Universal Declaration of Human Rights. And also, the combination in paragraph 1 and the wording of the combination paragraph 1 and 3, we see that the principle is grounded basically in fundamental human rights principles, especially the right to life, liberty, and security of a person. And by recognizing the right to international protection, the principle basically underscores the obligation of the states to protect and uphold these rights. Now, also in paragraph 2, we have a reference to the cornerstone of the international protection, and that is the principle of non-refoulement. But the combination of the wording of the 3 paragraphs, 1, 2, 3, we understand also that the principle is also consonant with other principles of international law, such as the principle of non-discrimination, non-penalization of illegal entry. Now, what I see is that in paragraph 3, the principle, the proposed principle is in line with the primary EU law, especially the subsidiary protection. But I'm afraid that this escape clause that these people must be protected as provided by national law might cause problems in the future in case this national law is never issued. And we see that in practice in other articles of our domestic constitution. So I think that maybe we should avoid having this escaping clauses. And also another comment I have is that I feel that maybe an expressis verbis acknowledgement of broader norms of international protection, such as the solidarity and burden sharing, and also an expressis verbis acknowledgement of the obligation of the states to promote the long-term well-being and integration of the refugees would be also an added value. Now, if the states incorporate the proposed principle in their constitution, I think also it's the only way to tackle the problem we face with divergent interpretations of the rights to international protection that we see in many constitutions, especially here in Europe. So we will have a uniform application, a uniform interpretation of the right to international protection. But I'm afraid also that since here in Europe, we have the primary law, and we also have acknowledged the importance of the Refugee Convention in our primary law. I'm a little bit afraid that if in our constitution we actually acknowledge a right that is based on this narrow definition of refugee, the definition of the Refugee Convention, I'm a little afraid that there might not be an added value to have this kind of right in our constitution. On the contrary, if in our constitution we actually have a broader definition of the refugee in view especially of the new dimension of displacement that we face around the world and the new situations we face, I refer to climate refugees. So if we actually have a broader definition of refugee in our constitutions, that would be also an added value, because that would mean that the constitution wouldn't be without an actual meaning. And my last comment also is that it's really, it's good to have constitutions with the rights to international protection. But here, especially in Europe, I think everything is dominated by the Refugee Convention. And I'm afraid that maybe the Refugee Convention here in Europe actually leaves the constitutional asylum in the dust, because everyone refers to the Refugee Convention. And in order to tackle this, this is the only way to tackle this is to have a broader definition of the refugee. And again, as we see with other, in other areas of law, it's good to have the constitution. It's also good to have rights constitutionalized, but sometimes constitution is not actually applied by the politicians. And again, we end up in understanding that it's again at the courts to actually protect the constitution and its meaning. And over the last years, especially in Europe, as I said in the beginning, we see that we face a lot of challenges as regards judicial independence. So this is my comment, and I'm really looking forward for the discussions later. Thank you.
Thank you very much, Judge Kotsopoulou. Thank you also for making a bridge almost between the previous topic and this topic by saying, okay, let's enlarge or broaden the notion or definition of refugee to include climate refugees, because indeed these topics become salient, and then the question of enforcement, you're right, and we will certainly come back to this during the Q&A. Let's now go to the last topic of today, which is automated decision-making, so Principle 32, and we have the pleasure to have with us and the honor Judge Maya Brkan, and she's a judge at the General Court of the European Union. She's also a professor of digitalization and EU law at Maastricht University, and she was previously Associate Director of the Maastricht Center for European Law, and she holds a PhD degree from the University of Ljubljana and an LLM from NYU. Judge Brkan has extensive experience and expertise in research and teaching in the field of digitalization and EU law, and of course, both as a judge and a specialist of digitalization and EU law, she fits perfectly well to make some comments on Principle 32, and I'm looking forward to her intervention. So you have the floor, dear Judge Brkan.
Thank you so much, Professor Pichonas, for your kind invitation to participate in this ELI webinar. It is a true pleasure and an honor to speak again in one of the events of ELI. Before I start commenting more specifically on Principle 32 on automatic decision-making, I would like to make an introductory remark, which goes back to what Professor Muir mentioned in her introductory remarks, and that is the question of horizontal application of fundamental rights, which is enshrined in Principle 28. But I believe that that principle is particularly applicable in the case of automated decision-making. So on one hand, we have this cross-cutting of automated decision-making with other principles, given the fact that paragraph 2 of Principle 28 states that those private parties that have a specific legal status, nature of activities, or a specific market position have exceptional powers and should comply with fundamental rights. So we do have a horizontal application on fundamental rights. And on the other hand, I believe also that the field of automatic decision-making reinforces this desire or this specificity of horizontal application of fundamental rights. So in a way, the principle of horizontal application of fundamental rights in the field of automated decision-making is an extension of the current case law of the European Court of Justice on horizontal application of fundamental rights. And here I can cite just a few cases, for example, the case Eggenberger on Article 21 and 47 of the Charter, case IR on Article 21 of the Charter, case Bauer on Article 31, paragraph 2 of the Charter, and the Max Planck case also on the right to paid annual leave under Article 31, paragraph 2 of the Charter. But I will now continue with the comments of the specific paragraphs of Principle 32 on automated decision-making. With regards to paragraph 1 states that the use of automated means to take decisions which affect the individual shall not undermine the safeguards and level of protection applicable by law to the rights or interests affected. And with regard to that first paragraph, I have actually two comments or questions. So the first is more of a question. So I'm wondering, is it possible or even desirable to maintain the exact same safeguards and level of protection that would apply in the case if a decision was taken by human means? And I believe here we actually have to make a distinction between, on one hand, the safeguards, and on the other hand, the level of protection. Because I believe that while the level of protection should be the same, the safeguards should be stronger. And let me explain myself. As the principles state, the level of protection of fundamental rights when it comes to automated decision-making and classical decision-making should be the same, because if we provide a higher standard or a lower standard for automated decision-making in comparison with the classical decision-making, then we would obviously create a disbalance or a lack of balance between the automated decision-making and a classic decision-making. However, I believe that if we apply the exact same safeguards to the automated decision-making as we apply to the classical human decision-making, that would, in my view, amount to a lower standard of protection of fundamental rights, because I believe that the safeguards that we are applying in human decision-making are not sufficient. So I think we need further safeguards such as, for example, safeguards of data quality, to detect the possibility of discriminatory decision already at the outset, even before the decision is taken, because there is a high risk that if, for example, an automated system analyzes numerous amounts of CVs of applicants for a job position, and there is just a human revision at the end, it is possible that that human at the end would not even detect that there is a discriminatory outcome, just because the parameters would not be entirely clear. So it is very important that the safeguards are already inbuilt in the process of automated decision-making, and that these safeguards are stronger and different than those safeguards that are in place for human decision-making. The second comment on that first paragraph would be quite a picky comment, I would say. So first paragraph speaks about safeguards and level of protection applicable by law, on one hand to the rights, and on the other hand also to the interests affected. And that notion of interest really attracted my attention, because in traditional fundamental rights instruments, the fundamental rights are protected, but there is no talk about the interest. So I'm actually wondering what this notion of interests refers to, and what kind of protection should we accord to these interests. So there are two possibilities. One possibility is to understand the interest only as a corollary of rights. So those interests that are stemming from fundamental rights are protected, but they're protected by way of protecting fundamental rights themselves and not independently of interest. The other possible interpretation is to protect the interest as a self-standing value, which would be, in my view, a novelty on the constitutional level. And then if that is the case, I'm wondering which interests would need to be protected. Are those private versus public interests? Are those private versus commercial interests, or all of them? And if the interests are protected as a self-standing value, which I don't think it should be the case, but I'm still trying to push the argument a little bit further, I believe that there are two reasons why these interests that are protected should be private interests. On one hand, because there should be a parallelism between fundamental rights which protect private interests and private interests that are protected as interest. And on the other hand, if we read paragraph 1 of Principle 32 in combination with paragraph 2, then it seems as well that private interests are at stake, because paragraph 2 of the same principle speaks about automated decisions which affect the rights of the individual, which is actually a question of a private interest. I'm now getting to the second paragraph of Principle 32. The second paragraph requires that where the authorities that exercise public functions use automated means to take decisions which affect the rights of an individual, automated decision-making must be transparent and accountable. And here I would like to draw some parallels or point to the differences with the currently current EU legislation. So when it comes to the principle of transparency, the principle, I would say, is mirroring in a way, or perhaps we could say that the AI Act is mirroring the ELI principle. Depends on from which angle you see it. But there is a parallelism between that principle of transparency in the ELI principle and Article 13 of AI Act. On the other hand, when it comes to the accountability, I would say that the ELI principles actually go further, because ELI principles clearly state the principle that there should be an accountability for the decision making with automated means, whereas the AI Act does not comprehensively regulate the question of accountability. There will be a question of a directive on civil liability, but this is something which is still in the process of adoption. So if I touch upon briefly just on that question of accountability, this is a notion which in my view raises several questions. And the core question, and this is the only part of that question that I will discuss today, is who should be accountable? And there are at least three possibilities. One possibility is that it is the developer that is accountable. The other possibility that it is the user that is accountable, so the deployer, if we speak in the notions of AI Act. And the third possibility that it is the AI itself that is accountable. And many legal philosophers claim that it should be the AI itself that is accountable, but I'm very much warning against that option in my academic writings, because that would imply that we give the AI a legal personality, and that would also beg the question of what kind of sanction could we apply to the AI that could be deterrent from making the same violation of fundamental rights in the future. I personally believe that the best possibility of liability would be the joint liability of developer and user, because an AI system could be actually, I mean, violating fundamental rights on one hand because of the configuration, the initial configuration of how it was developed, or it could be violating fundamental rights by the specific use of the user. And here I always give the example of a robot that is powered with AI and that is actually used, for example, in prison by prison guards. If the robot is not configured in a way to cause harm to the prisoners, then obviously the developer cannot be accountable. But if that robot sees, for example, the prison guards to treat inhumanely or sees a degrading treatment by human prison guards, then it learns from them, then I would say that the user should also be accountable for showing a certain way the AI should behave or decide. So that is on the accountability part. I'm now going to comment also on the transparency part of that second paragraph of the principle 32. And in that regard, there is a quite a detailed commentary with that regard. There is a commentary of that principle which states that the person concerned must be informed in advance that the decision is taken solely by the automated means. And I don't have any specific comment on that part. But there is also among the comments a comment in the explanatory memorandum to Principle 32 that the role of technology and the general principles of the methodology used to arrive at the decision must be explained in advance in an intelligible form to the person concerned. And I think this idea of explaining in advance the logic of automated decision making is something which is a relative novelty in the legal sphere. And I say a relative novelty because if you look back in 2017 and in the seminal article of Wachter, Mittelstadt, and Floridi about the right to explanation or non-existence of the right to explanation in the framework of Article 22 of the GDPR, they have actually read in the framework of the GDPR an ex ante approach, which corresponds to that ex ante approach enshrined in Principle 32. And if we look at Article 13, 14, and 15 of the GDPR, they require that a person should be informed about not only the existence of automated decision making, but also meaningful information about the logic involved. And there has been a huge discussion in the literature what that means, whether that means the right to explanation or not. But I believe that the ELI principles are quite clear in that regard, that there should be a right to explanation. So the decision according to the explanation of the Principle 32 must be reasoned. And that is really, I would say, $1 million question. What exactly should an explanation or a reasoning of such a decision contain? If we compare the Principle 32 with Article 86 of the AI Act, which clearly enshrines the right to explanation, I would say that ELI principle goes further than the AI Act. It goes further because it is not limited, contrary to the AI Act, only to the high-risk AI systems. It goes further because it is not limited to require explanation only from deployers, as does AI Act. And it also, in a way, goes further because it could be understood in a way to require explanation for all of the automated decision, not just for those that substantially affect the fundamental rights of persons involved. However, on that last point, if we look at paragraph 2 together with paragraph 3 of the principle on automated decision making, it could also be argued that the decision is required to be explained only when a decision affects substantially the rights of individuals. So this would probably depend on the practical application of this principle. And that brings me to paragraph 3. Paragraph 3 states, the law shall lay down the categories of decisions which must be subject to human review by virtue of the fact that they affect substantially the rights of the individual. And here I would have 2 comments. The first comment would be that it is sometimes in practice difficult to delimit the categories of decisions that need to be subject to a human review. Because in practice, even decisions which on the face value wouldn't have a huge impact on the person can have a very big impact on the person. And a typical example could be deepfakes. Deepfakes in AI Act are not per definition considered as a high-risk AI systems. However, deepfakes can actually have a profound impact on fundamental rights. If we remember the case in Spain where certain school children created a naked picture of their fellow students, that had a profound impact and a breach of fundamental rights. So that somehow low risk AI systems could have an impact on fundamental rights. So I believe that probably the most logical approach is not to try to forcefully categorize the decisions that need to be subject to human review, but to actually have recourse to the principle itself. And that brings me to my second comment. The principle says that those decisions that affect substantially the rights of the individual must be subject to a human review. And I think this is the best criteria. And here I would like to put forward a comparison with Article 22 of the GDPR. If we look at the text of the Principle 32 of the ELI, which states that human review must be given whenever a decision affects substantially the rights of the individual. And if we compare that with Article 22 of the GDPR, which talks about legal or similar significant effect, I'm wondering whether the formulation from the ELI principles that they affect substantially the rights of the individual means also that the legal effect also needs to be substantial. Because when we look at the GDPR, it seems that any legal effect, even a minor legal effect, would not be authorized by Article 22. But if we literally read paragraph 3 of Principle 32, we could ask a question whether just a substantial legal effect would need to be reviewed by human. But I would say that if we have recourse to a teleological interpretation of the principle, that shouldn't be the case. But still, the question is there. And that brings me to my last point, and that is a comment on paragraph 4 of the principle on automated decision-making. According to paragraph 4, automated decision-making shall not prevent or unduly limit the exercise of the right to judicial protection of fundamental rights. And if we read the commentary of that paragraph, the commentary states that there should be a right to judicial protection by a human court. And I would strongly propose, or perhaps suggest that it would be desirable that the right to judicial protection by a human court should stem more clearly from the text itself of the principles. Because if we look at paragraph 4, paragraph 4 speaks only about the right to judicial protection. It doesn't speak about the right to a human judicial protection, if I may say so. But I think it would be desirable that the text say so. And when we come to the human review of the automated decisions, I reflected a lot about how to frame that human review. And I believe there are 3 possibilities. The first possibility is to have a classic review of legality, just like as we do right now at the General Court. We review the legality of decisions of the Commission, of the Council. We look at the evidence, we look at the reasoning, we look at the motivation, etc., etc. This is one possibility. The other possibility is to change the degree of judicial control and to actually have the same type of control as in complex medical assessments, or as in complex scientific assessments, or as in complex economic assessments as well. As you might know, that in case of authorization of a marketing of a new I don't know, a medical product on the market, or in case of a complex economic assessment in competition law cases, the courts usually have a restrained control. And that means that they only look at the manifest error of assessment. I would strongly urge against the application of a standard of manifest error of assessment in case of automatic decision-making, because that means that we could really overlook decisions that affect fundamental rights, perhaps not substantially, but still affect them, and that should be sanctioned. So I really would not be in favor of that. I would be in favor of a third approach. And third approach is the approach according to which the final decision of the automated system would be submitted to a review in which a judge would be authorized to make a de novo assessment. And that means that the judge would be able to substitute his or her assessment, the assessment of the ADM with his or her assessment. And I believe this is, for me, I would like to say this is the only right way, but it would be a little bit too strong to say that. But I believe this is a path which I think we should reflect on, because if we do not have the possibility of de novo assessments, many technical bugs could go unattended. And if we would need to really explain ourselves why we depart on the decision of the automated decision making, sometimes it would be difficult to find reasons. But if we would give the judges the possibility of a de novo assessment, that is something that I think would really strongly protect fundamental rights. And I believe that this is something that we are striving for. The question is, of course, whether that will speed up the decision-making process or not, but that is perhaps the questions that I would leave for the discussion. Thank you very much.
Thank you very much, Judge Brecan, for this very thorough analysis of Article 32. And we still have a little bit of time for the discussion, fortunately. So we will certainly be able to answer some of the questions. But thank you already to all the panelists for your very interesting comments or analysis. I would like to begin, in fact, to hand over to Elise Muir, because she might want to react to a number of comments and points that have been made. And so, Elise, you may react now.
Thank you very much, dear members of the jury, of the panel, sorry, for these comments, all very incisive and very helpful. I think the broad scope and the depth of the comments you have given shows you how challenging it has been to try to put together not just 3 principles, the ones you commented on, but actually 36. So I'll just try to pick up on a couple of things. First, one point that comes back a few times in your comments is this issue of implementation. So how do we turn the principles into reality? That of course is inherent in this exercise. We were asked by ELI to draft principles. And so we are aware that there is a sort of a gap showing the implementation of the principles asserted in the Charter. So this tension between the principles and reality is inherent in the Charter. It also means we've had to make choices and balancing competing interests in the Charter. So for example, Judge Koutsopoulou, you mentioned this reference to national law in the principle, and you regretted it. And I noticed that someone in the chat also picked up on this. Well, you may be right, in the same way as Professor Van Calster says, well, instead of calling for coordination between states at international level, we should call for actual international law commitments at international level. So I think both sets of comments are fair, again, because of the nature of the Charter, which is not a constitution, it is not a political program, it is a text that seeks to find and build consensus around very fundamental principles at European level. We chose sometimes some slightly more careful wording and less engaged wording. Now, to sort of address this comment perhaps a bit differently and more positively, we do have a principle in the Charter, which is principle number 12, which calls for respect for international law. So existing commitments on international environmental law or the rights of migrants, which is something you were calling for, Judge Koutsopoulou, as well, that we should acknowledge more generally the importance of international law. I think in these 2 fields is particularly clear. We also sort of had a principle, an overarching principle, saying, well, the rule of law implies respecting international law commitments adhered to by states. So that was something that we wanted to assert as well in the Charter. Now, you have understood that the 3 principles that were discussed today, on environmental protection, on international protection of migrants, on automated decision-making, these are particularly sensitive and moving targets, perhaps less so for the rights of migrants, but on environmental protection and automated decision, the law is evolving. And so it is true and sustainability, environmental protection and sustainability, and automated decision-making, as commented and observed by Judge Berkan and Professor Van Calster, could still be deepened and reflected upon. Now, surely what we did not want to do is to be over-prescriptive. So some of the topics that have been addressed in the discussion, I think, are extremely helpful to further the reflection on how to put into practice these principles. They may require, again, fine-tuning of the principles themselves. But something we did not want and could not do, I think, in this Charter was to go too much into the details on accountability or the duties of private parties in international law commitments, which is something, again, Professor Van Calster warned against doing anyway. But so these are just general comments I wanted to point out. Now, if I may, but should you want me to, I could pick on some of the comments in the chat, President Pichonas, but I'll give...
yeah, maybe that could be good, so that then I could, if there's some more time, ask one or the other question to the other panelists. But if you want to react on one or the other questions, you may. We do not have much time, but if you synthesize, that's good.
Right. Well, I think there were two. So there was one point I already indirectly addressed. There were two comments on one on accession by the EU to the Council of Europe. That's clearly a typo. Thank you for pointing it out, and we'll have to address this. More generally, I think this typo is useful, and your comments, Mr. Mader, is useful because it shows how intrinsically connected the EU and the Council of Europe have become on these issues of values and fundamental rights in particular. And I think this is right, it's not just about the ECHR, it's also about the entire work of the Council of Europe and the multiplicity of collaborations that there exist between these two bodies to consolidate European constitutional democracies overall. So I think it's a helpful typo to stress the importance of the two systems. And on the issue of class action, so on the issue of who should be empowered to litigate, in general, litigating fundamental rights protection in general, I certainly think that we are quite far from a general principle on collective action. There are developments that are really interesting. And for example, the EU has been trying to encourage some forms of collective action, but we're quite far from having a general principle. Whether that is more advanced in the field of environmental protection in particular is perhaps something I would maybe invite Professor Van Calster to comment upon. I'll be cautious on that, although I find this interesting for reflection. Thank you very much. This is just a quick...
Yeah, thank you very much. And indeed, I wanted to hand over to Professor Van Calster regarding this collective redress in environmental law. And because there was also this general question about enforcement that was tackled also by Professor Muir, but it's very nice to have fundamental high-level protection for environmental and sustainability, but how can we put that into action if there's no collective redress, and how do you see this position?
Thank you. I'll answer very, very briefly, and I answered some of it in the chat already. I think, first of all, what's very useful, and I forgot to flag it also due to time, of course, is what Professor Muir in her introduction emphasizes Principle 28.2. The sort of horizontal relationships between private parties, effectively. I think that's a great call by the principles, because clearly that certainly helps. And as we know, it is being tested in quite a few cases, like in the climate case against Shell, and so on. So that, I think, is a very useful instrument. On collective mechanisms, of course, it's very difficult internationally, as we all know, to introduce much harmonization on civil procedure, because that's what we're really talking about here. It's not straightforward to do. The European Commission has no plans, I don't think, to introduce any of such collective mechanisms in the environmental field. Some suggest that the Århus Convention would, at the very least, encourage such an introduction. I'm not so sure whether actually it does. But in the meantime, we do, of course, see that there are a number of member states who either already traditionally have or are certainly developing some very effective collective mechanisms. The only challenge with those is that very often, for there to be a collective action, you need to show actual damage. And of course, then you start reducing the pool of people that you might be able to bring before a court to, often a smaller group. And as we know in the European Court of Human Rights, thankfully, the court at Strasbourg has recognized that for some of the climate cases, at least, there are such people who can show that sort of a damage element so as to bring their case forward. But it's clearly quite an important obstacle. So should we have such instrument? Yes, I think it would be great. Are we going to see that even in the long term? I don't think so, because international organizations shy away from intervening too much in these civil procedure rules, and therefore we're left with trying to move the boundaries by litigating on the basis of national procedures. That's not ideal, but it kind of works in quite a few cases.
Thank you very much. But of course, everyone has in mind the Klimasignorinen against Switzerland. And there maybe that shows a new trend that may come in indeed. I had a question because you mentioned, Professor Kalster, the issue of coordination with other standards to set up the standards. I think you mentioned that, or maybe I'm mistaken. But there's of course one problem when one speaks about high level of protection. It's the balancing of this right against other rights of the same charter. And at the same time, coordination, which means that you have to coordinate to have a similar definition, but then you have to balance within a specific case or within a specific charter like here. So how do you see this opportunity? Is it not too dangerous to just go forward and say, let's coordinate or let's have an international convention and forget about the balancing and the proportionality that is at the center?
I once wrote an article with the title Against Harmonization, and that was on climate change regulation. So it links a little bit to what I suggested on, from a sort of personal and policy point of view, I'm very much a multilateralist. But I think, unfortunately, to really advance the status quo in a number of really pressing issues like migration, like climate, we need a few front runners. And I'm pleased to see that, at least for climate, the EU is turning towards being such a front runner, including on unilateralism. But of course, the problem indeed with coordination is that from the moment you try and coordinate anything in sustainable development, you'll have the Mauritanias of the world that will say, we need to really achieve a certain standard of living first that you guys have achieved since the 1800s or the 1900s before we start thinking about proper environmental protection. So, when you start coordinating internationally, you'll always have the problem of finding the sort of common ground and watering down on standards which, frankly, are quite achievable for some states, but not at all, economically speaking or politically speaking, for others. So coordination, I think, is something that one needs to do carefully, because it mustn't distract from the value, I think, of proactive action by some states, even if that proactive action might be legally vulnerable.
I see. Thank you very much. Judge Kotsopoulou, I wanted to give you the floor for maybe last remarks or comments or reaction, because you also were, in a way, between two chairs. One was to say, okay, let's have it in, let's have the right to asylum in constitutions, but at the same time, you also said that the Charter should acknowledge further conventions on international level. So there's a kind of tension here. So I'm just interested to see whether you have to add something or to react on something else that has been said before.
Yes, thank you. Well, I understand what balance is. A judge, actually, this is what we do in our everyday life. We're trying to find balance. And migration is one of these topics that we always try to find a balance. On one hand, we have the state. On the other hand, we have the refugees, the asylum seekers. But here in Europe, what I say is that we have acknowledged that we have the Refugee Convention, the primacy of the Refugee Convention. And we have also agreed that we have the subsidiary protection. So someone can argue that since we have agreed on this, what is the added value of having a constitutional right to asylum? We have the primary law that covers everything. So this is why I believe that in order to find the, the fait utile of a kind of constitutional right, then we must have a broader meaning. And on the other hand, I understand what Professor Muir said as regards the escape clause, and I read the comment, the Q&A place. Well, here in Europe, we have agreed that we have the subsidiary protection, and it is an obligation for the state. So why should we have in our constitution a subsidiary protection form with an escape that is a little bit narrower than the primary law and the secondary law in Europe? But I understand we must find balance. And sometimes, maybe it's romantic because maybe we believe that something must change. but it's not the reality that the reality doesn't let us change it. Maybe in the future. Thank you.
Let's see. Thank you very much. Let's see. I give also the floor for some last words to Judge Burkhan. So you are happy to comment or make a final point.
Thank you very much. Just a final point that I believe that the ELI principles are a very, very important document also, not just in a European level, but also international level, because I believe that they institute the highest common denominator in the field of automated decision-making. And we see that in certain other countries where automated decision-making is left to self-regulation, we are left with the lowest common denominator. So you do very important work, and I would like to just thank you for that. Thank you.
Thank you very much, and thank you again for also your very detailed comments, and we look forward to your future writings in this respect. With that, we have come to an end of the time allotted to this lunch webinar, so work will start again for all of us. Let me just remind you that we have a last webinar on this charter, webinar number 7 on the 17th of June 2024, again a lunch webinar, and it will be dedicated to constitutional integrity. Let me also thank very warmly all our speakers of today. That was really fantastic to have you all around the table discuss these very diverse topics, but in a way that was really useful and understandable for all our attendees as well. Thank you to Elise Muir, of course, and the other co-reporter, Takis Tridimas, for all the work that has been done and for the presentation. Thank you for everyone for being here. Thank you to the Secretariat of the ELI for organizing this webinar. And I look forward to meeting you all very soon again in one of our webinars, and at the latest on 17 June for our webinar number 7. Have a good day. Bye-bye. Thank you.
Thank you.